Good afternoon again. My name is Raymond. I am an advocate with Disability Rights California. I want to quickly do an overview of who we are in case you're not familiar. Um, and thank you for joining us, and we embrace for having us here. Mina couldn't join us today, so this will be recorded, and all the materials along with recording, you can reach out to her at We Embrace to get the recording and materials. So again, my name is Raymond. I'm an advocate and Disability Rights California, or DRC. We are a statewide nonprofit, and we provide free legal services to people with disabilities with any disability-related issues. We have offices statewide, and attorneys and advocates can help with different subject matter, such as access or discrimination with housing, with transportation, with education. We can also help with some employment reasonable accommodation issues, and we can help with public health benefits such as Medi-Cal, in-home supportive services, and social security overpayment issues that relates to work. And within our agency, we also have separate programs such as our Office of Client Rights Advocacy. They specialize in helping clients of the regional center, and our Client Assistance Program. They specialize in helping clients of the Department of Rehabilitation. There will be a question and answer portion after the presentation when the recording is stopped. If you have any questions during the presentation, feel free to type in the chat. Just keep in mind to not put any personal identifiable information in there. This is to protect your privacy. If you would like to make an appointment, speak to one of our advocates, you're more than welcome to reach out to us. Our number is 800-776-5746. And our phone lines are open Mondays, Tuesdays, Thursdays, and Fridays from 9 a.m. to 3 p.m. And if you call us outside those hours, you can leave us a message, and our advocates will get back in touch with you as soon as possible. So with me again today, we have our wonderful presenter, one of our senior attorneys, Maria Ariate. So take it away.
Thank you, Raymond. Hi, everyone. So today we're going to talk about what happens after you get a notice of action. It's really the part 3 of our 3-part series on IHSS. The first one was basics. The second one was how to prepare for an assessment or reassessment. And here it's really about what do you do? How do you prepare for a hearing? And so we're going to review a little bit about what an adequate notice of action is, a timely notice of action is. We're going to use a hypothetical and see how this mom prepares for an IHSS hearing, what happens during the hearing, and some things after the hearing. So we're going to use the case of Emilio, who's 12 years old. He's a young boy with autism and auditory processing disorder. He's been receiving IHSS protective supervision for years. And at the last reassessment, which happened in November of 2024, the social worker kind of hinted to mom that she didn't think that he would be eligible to continue with protective supervision. Of course, mom was a bit upset, but became more upset when she received the notice dated January 5th of this year saying that they were going to take away the protective supervision for 2 reasons. The first one is that he is self-directing, and the second one is that he doesn't need 24/7 supervision. Now, mom doesn't really understand where this is coming from. He's had protective supervision for years, and of course, she reads the notice of action and she understands that if she appeals before the effective date of the notice, she will he'll be able to continue with her protective supervision until there's a hearing decision. And if he wins at the hearing, of course, he'll continue with his protective supervision. So let's talk about notices of action. Whenever you apply for a public benefit program, you should get a notice of action either saying you're eligible or not eligible. And if it says not eligible, it tells you what your appeals rights are. And so it happens when there's eligibility denial. It happens when they deny a service, reduce a service, terminate a service. that's when you'll get a notice of action for IHSS. Now, there's a term in law called adequate notice, and it means that the law requires that certain things be in this notice. First of all, what they intend to do. We know that what they intend to do here is take away Emilio's protective supervision. Why? Because he's self-directing and he doesn't require 24/7 supervision. The notice also should have the regulations, the codes, anything that supports their decision. And importantly, the explanation of the right to an appeal, how much time you have to appeal. In an IHSS matter, you have 90 calendar days from the decision. But there's something called aid paid pending that's really important. I just want to make you aware of something. So when you appeal and ask for aid paid pending, what the county wanted to do will not happen until there's a hearing decision, and hopefully you win and you continue with your service. What the county will do when you ask for aid paid pending is send you a subsequent notice reestablishing what they wanted to take away. And some people get confused and think, oh, I appealed. I guess the county changed their decision and now they're not going to, for example, in this case, take away Emilio's protective supervision. That's not what's happening here. What's happening here is that that's the notice putting the, saying, oh, we're not going to take away the protective supervision because you asked for aid paid pending. So don't get confused when you get that second notice and they put, they undo what they were going to do. It doesn't mean that you're not going to have that hearing. It just means that you asked for aid paid pending and the matter will continue to a hearing if necessary. And if the county needs any information, it'll tell you in the notice of action. So if there's something the county needs, give it to the county and see what happens afterwards. But so this is a typical notice of action for someone who already is getting the service. So you'll have up on the top right corner, you'll have a notice date. Notice date is the date they prepared the notice. So in Emilio's case, it was, I forget, January, let's say January 1st of 2025. So that would be the date. Actually, that would be it. No one's working on that date, but let's say January 2nd. And then case information. And then here it says, as of, and let's say that it says as of February 2nd, 2025, Emilio, the protective supervision is going to be taken away. And the notice says, if you appeal before the effective date of the notice and you ask for aid paid pending, come February 2nd, nothing will happen. You'll continue with, in this case, Emilio will continue with his protective supervision until there's a hearing decision. So the effective date of the notice is here in this rectangle. It's not the date of the notice. The effective date is when the thing is going to happen, right? They're going to take away the protective supervision February 2nd. So this is really important. Lots of people don't read the notice. They let the paid pending go by, and then maybe they realize that they could have done this, but it's too late. If you have indicated to the social worker that you want your notice in your language, and your language is one of those threshold languages in the county, what does it mean? So long as your language is spoken by at least 5% of the population, it's a threshold language, and therefore the county has to give you your notice in your language. If your language is not a threshold language, then the county has to provide interpret the notice of action or for you, basically. And there's a time period to ask for that. So important point is language compliance. There's another concept in the law called timely notice. So the notice has to be mailed to the person affected at least 10 days before the effective date of the action. So in Emilio's case, the effective date is February 2nd, so it has to be mailed at least 10 days before the effective date of the action. Read that notice. I talk to parents or people who have received a notice and I'm on the phone with them and I ask them, one of the first questions I'll ask is, did you appeal? And they'll say to me, well, I don't know how. Well, that to me indicates that they didn't read the notice because the notice tells you how to appeal and how much time you have to appeal. And if you go to this website here, it tells you the different ways that you can appeal. You can send it in. You can call the state fair hearings number. That's how I used to do it. I would just call the state fair hearings appeal and they would give me a case number right away. And if they couldn't give me a case number, because that happened a couple of times, I would call the next day because the case number is your proof that it has been filed, that you appealed. So that's the way to do it. Now, sometimes people get notices and they're not quite sure whether they want to appeal or not. Go ahead and appeal because it's very easy to withdraw your appeal. If later on you decide you don't have a good case or you just don't want to appeal, you can call state fair hearings and withdraw. That's easy. It's very hard to appeal late. If you pass the deadline for appealing, you're going to have what they call good cause for appealing late. Pretty much you were in a coma, something significant, that you didn't understand it, is not going to be sufficient now, that it wasn't in your language and you had requested it in your language. That could be a reason for good cause because the county should have been language compliant if you asked for it. So there's the California Department of Social Services administers the IHSS program, and they issue all county letters, all county information notices to counties. And this information here happens to be an all county letter about withdrawing your hearing request, rehearing request. I'll talk about that a little later, conditional withdrawals, which I'll talk about in a moment. So good information for you to look at. So a conditional withdrawal. After Emilio's mom appeals, at some point she's going to reach out to the appeal specialist because she's going to get a letter from this appeal specialist saying, hey, I'm going to be representing the county at the hearing. These people are not attorneys. Most likely they were social workers before and probably were promoted. Not all of them. Others may have come from other areas, but usually that's the case. And the appeal specialist may say to mom, hey, you know what? Let us reassess Emilio for protective supervision. And the mom has two options. She can say, no, I want to go to hearing. And she could say yes. And she might be tempted to say yes because she thinks that if they reassess him, maybe they'll decide differently. Maybe they'll decide that Emilio should continue with his protective supervision. And if she says yes, then the appeal specialist is going to ask her to sign a conditional withdrawal. It's a document that says what they've agreed to. So we're going to reassess. It has to be done within 30 days of signing the reassessment. Mom should understand what she's agreeing to. And if there's any retroactive award that could have been gotten, so let's say that you didn't ask for aid paid pending. Let's say mom didn't ask for aid paid pending. Come February 2nd, Emilio no longer has protective supervision. There's a hearing 3 months down the line. He wins. So there's a retroactive award of 3 months that he didn't get the protective supervision. Mom needs to make sure that that conditional withdrawal protects that retroactive payment. So that's a conditional withdrawal. Now, don't be fooled into thinking, or here, mom shouldn't be fooled into thinking that if she says yes, go ahead and reassess him, that they'll continue to give him the protective supervision because they can reassess him and send another notice of action, still taking it away. But this time they are now more prepared than they were for the hearing, because it could be that they really did a shoddy job at the reassessment, and now with this new assessment they have more info, right? More evidence that they think they need in order to win their case at hearing. The MPP is Manual of Policy and Procedures. There are procedures, there are regulations as to procedures at state fair hearings. And so when the conditional withdrawal procedures are found in this section. And I'll show you the link to where you could find all of this. Conditional withdrawal. Okay, appeals case management system. This is a way to manage the case electronically. You don't need to do this. I'm going to go ahead and open up the link so that you can see. So mom can decide that she wants to manage the case electronically. In other words, she's going to create an account through the appeals case management system through the State Fair Hearings Office, and she is going to use this to manage the case, the papers. So she can always log into the case, see what documents have been uploaded to the system. And so she can also, when she's ready to send her evidence and maybe her position statement for that hearing, she can do it through the ACMS system. She'll also be able to see whatever the county's position statement, because the county has to give her a position statement. I'll talk about that a little later. And the evidence that it's going to use at the hearing 2 days before the hearing, and the county will upload it to the system. So it's an easy way to, well, if you're comfortable using computers and doing all of this electronically. And so it's an option for mom if she wants to do it. So I'm going to stop sharing. Okay. When you're appealing a notice of action, if you need an interpreter, ask for an interpreter. You can ask for an interpreter at any time. Let's say that Emilio's mom decides that she can do this without an interpreter. She's at the hearing and she's not understanding everything. She can stop the hearing and say to the judge, I need an interpreter. I'm not understanding everything that's going on. And the judge will try to find an interpreter. They can find an interpreter through the phone. The interpreter doesn't need to physically be there. And if the judge can't find an interpreter, then the hearing will be continued. A reasonable accommodation. If she plans to have Emilio at the hearing, she may ask for Emilio to have the reasonable accommodation of maybe, giving him a break every 20 minutes. Although I've had kids at hearings and the judges would usually just keep the child there for a little while just to see. But I've never had a child stay at the hearing the entire time. It just doesn't work out. They get restless and other things. And so it's more for the judge to observe the child. Mom may have her own disabilities and she may ask for some kind of accommodation, maybe that, everyone speaks slowly because of her disability, but she has to ask for the accommodation from State Fair Hearings. Subpoenas, you can subpoena people to the hearing. That's forcing someone to come to the hearing. Subpoena documents, making sure that documents get to the hearing. If mom, for example, finds out that the social worker who did the assessment is not going to be at the hearing, she could ask State Fair Hearings to allow her to subpoena that social worker, because she may want to cross-examine the social worker about things that happened at the assessment and why she thinks that Emilio is self-directing and why she thinks that he doesn't require 24/7 supervision. But you have to go through State Fair Hearings just to have a subpoena issued. Mom, let's say that the hearing was going to be next week and mom is just not prepared. She's been waiting for a doctor's report. She can call State Fair Hearings and ask that the hearing be continued. They're going to want to know why. The first time around shouldn't be too much of a problem. But every time you want to continue the hearing after the first one, it's going to be harder. You're going to have a really good reason for continuing the hearing. By law, you're entitled to an in-person hearing, but what's happening nowadays is that the hearing, the letter that tells you when the hearing is going to take place will say that it's going to be a virtual or by phone, whatever it may be. But mom may decide, no, I want an in-person hearing, and Emilio has a right to an in-person hearing, and mom can call their hearing office and say, I want an in-person hearing, and they'll say, okay, but do you know that means that we're going to have to postpone the one that is currently set, and yours and Emilio's will be set further out. And she says, fine, I want the in-person hearing. It could be, there have been home hearings where the person can't leave the home but wants to participate in the hearing. And for whatever reason, the phone or video is not going to work. So you can have everyone come to the home. Expedited hearings it's like cutting in front of the line. There are all these people waiting for their hearing dates. And so an expedited hearing, you can ask for one, but you have to have a really good reason. A good reason would be, for example, the whole purpose behind the IHSS program is to keep people in their homes with services and supports that are needed. So if I'm about to lose my home because I can't get help at home and I'm going to, be out on the street, for example, that would be a really good reason for asking for an expedited hearing. The length of the hearing is usually calendared for 2 hours. I've had hearings that go on for 4 days, not consecutive days, because if we don't finish on the first day, it's set for another day in the future. So, it just depends on what the issues are at the hearing, how much evidence is going to be presented. Lots of things can come up during the hearing. So mom appealed, and she's going to get a letter from State Fair Hearings confirming receipt of the appeal, and that she's going to hear from the appeal specialist, and then she's going to get that letter from the appeal specialist. That all county letter that you see there is really important because appeal specialists have an affirmative obligation to try to resolve the case short of going, so that you don't have to go to hearing. I've had occasions where the appeal specialist says to me, you know what, my hands are tied. The social worker and the supervisor won't let me settle this case. And so we're going to need to go to hearing. And I'll bring it up at the hearing. But it is an important responsibility that they have. And maybe when mom is talking to the appeal specialist, she might want to remind her or him that, one of their duties is to try to resolve this. And she's given them all the evidence that they need in order to continue his protective supervision. And so what's going on? Then mom will get a letter with the date, time, and place. Like I said, it's usually going to be phone or Zoom. And if she wants an in-person hearing, she can have an in-person hearing. So when we're talking about hearings, there is a whole section. There's there are procedures that need to be followed. Okay. Those procedures are found in MPP 20-000. So we're going to go to that link first. I included the administrative law judge bench book because it informs me what judges have to do and what they have to consider under certain circumstances. So it helps me form my argument and get my evidence for what I need to do procedurally in a case. So if we go to the first link, which are the regulations on procedures at the hearing, let's see, let's do this. Okay, so this is State fair hearing definitions is the first section. Time to file for hearing, the right to a state fair hearing, how to request a hearing. And then we've got acknowledgement of request for the state hearing. Remember that letter. Setting the hearing, group hearings, general rules and procedures regarding hearings, all about evidence, subpoenas. If you're going to subpoena a witness, they're going to be paid witness fees and mileage, and what that talks about what that is. How to postpone, continue, dismiss a case, disqualify a judge, communications after a hearing, the notice of decision, the alternated decision that the director of CDSS can take. I'll talk about that, about rehearings. So this is an important, these regulations are important to look at, to understand procedures to follow when preparing your case. The ALJ bench book, let me open that up. It has all kinds of subjects. Abandonment. When can a judge consider a case abandoned? Let's say I appeal and I don't go to the hearing. So this talks to the judge about, well, how much time do you have to give the claimant, the person who filed the hearing, so that it's not abandoned? What is it that they need to do? Sometimes you need to ask for aid paid pending from the judge because the county's refusing to give it to you. Your authorized representatives, what needs to happen at the hearing. If you bring someone to the hearing to represent you, and there's a form that needs to be filled out, and the judge needs to make sure that happens. How to deal with continuances, how to deal with disruptive participants, etc. Ex parte discussions, one-sided discussions are not allowed. The forms that could be used at the hearing, interpreters, oaths, etc., rehearings. Anyway, lots of good information. So let's go back to this. Okay, so now let's talk about how Emilio's mom is going to prepare for this hearing. So the first thing she needs to be very aware of is, what is the issue for the hearing? It's very simple. It's in the notice of action. The issue for the hearing is that the county is wanting to take away the protective supervision. And she can find out more about the county's position when she reaches out to the appeals specialist to talk about the case. She could learn about the evidence that they're going to use at the hearing to establish that he no longer needs protective supervision. Mom has the right to review Emilio's file. That's the MPP 22-051.1. And so she could coordinate with the appeal specialist to review the file, because when they do assessments or reassessment, there are forms that the county workers are using, and you can find out really good information by reviewing those forms that have been completed by the social worker. The county's position statement. The county has to give mom its position statement. It's a lot like a notice, like what they did, why they did it, what laws, regulations, etc. they're relying on, their argument, the evidence that they're going to use, and the witnesses they're going to bring to the hearing. But you only get the position statement 2 days before the hearing. So it's not a lot of time to review. And if you think that you're going to start getting prepared 2 days before the hearing, that is a bad idea. By the time you get the county's position statement, you should be pretty prepared for the hearing. So don't think, oh, I'll just wait for the county's position statement and then start preparing. That's a bad move. And so that will also inform mom. But we know what the issue is. Really, the issue is taking away protective supervision. About the county's position statement, mom can decide that she'll receive it through the email. If she's signed up for ACMS, it'll be there 2 days before the hearing. She can decide, and she needs to coordinate this with the appeal specialist to pick it up at the office, have it mailed to her. More information about the county's position statement is in this, excuse me, all county letter. Okay, second thing, mom has to understand the law. Excuse me. So the notice said that they are taking away the protective supervision for two reasons. That Emilio is self-directing and that he doesn't need to be supervised 24/7. Mom has no idea where that came from initially. But as she started to review DRC's website, we have a publication on specifically on protective supervision. We have a manual also on IHSS that talks about protective supervision. And then she reads the All County Letter 15-25 that talks about protective supervision, and the regulations that govern the IHSS program are found in the MPP starting at 30-700. So if she goes into the regulation, she's going to find all kinds of information on protective supervision. So after reading all of this, she understands for the first time that protective supervision has criteria. So you have to show that the person who is asking for needs the protective supervision has a mental disability, whatever it may be, could be psychiatric, developmental, traumatic brain injury, Alzheimer's, whatever. And that mental disability makes the person non-self-directing, meaning that because of the mental disability, the person doesn't understand that the behavior they're about to do or are doing will cause them injury. So someone who's non-self-directing will turn on the hot water faucet and put his or her hand in the hot water, not realizing that they're going to burn, and would continue to do that time after time after time because they just don't understand. The second criterion is that they have to be able to engage in potentially dangerous activities. They have to have the physical ability to get into danger. They don't have to necessarily injure themselves. Protective supervision is to prevent the person from doing the activity, right? Or stopping the person from doing the activity. You have to show that the person needs to be supervised 24/7. Okay. The program doesn't pay for 24/7 supervision, but it is a criterion that needs to be met. And for minors below the age of 18, you have to show that the minor needs more supervision than a minor of the same age without a disability. That to me is very easy when you start talking about behaviors. So out of the 4 criteria that you need to show to get protective supervision, the county is saying that he doesn't meet 2 of them, right? So now she understands why those 2 things are in the notice of action, the reasons for taking away the protective supervision. And by the way, you can go, this is a link that takes you to a decision registry. So you could look up decisions that have been issued by judges in the past. Mom may want to look at some protective supervision cases to see how the judge addressed the issue, the law, and what facts supported the judge's decisions, right? So it's informative in that way. Burden of proof. Okay, so just hang tight because these are things that are important. In IHSS hearings, the standard that is used to prove the case is by preponderance of the evidence, meaning that you have to show that their need for services is more likely true than not. Now, if the county denies the IHSS application or seeks to reduce or terminate services, as is the case here, the initial burden to present evidence supporting its decision is on the county. So at the hearing, the judge is going to turn to the county and say, okay, this child has been receiving protective supervision for years. Now suddenly you're saying that he's self-directing despite his disabilities and that he doesn't need 24/7 supervision. Show me the evidence. And the county will show whatever evidence it has. Maybe it's good evidence or maybe it's not so good evidence, but it's evidence. And then once the county does that, then mom will have to provide evidence to refute the county's evidence. So that's the way it works. For eligibility, for example, yeah, so you're going to have to show it, so you're going to have to show why obviously the county's going to have to show why the person doesn't qualify, and then the person has to show why they qualify. Okay. Weight of the evidence is something different. So what a judge will do is the judge is going to take all the evidence from each side and ask, which side's evidence is more convincing and should be considered more reliable when making a decision, okay, based on the preponderance of the evidence. So the judge will weigh the evidence. Let me give you a really good example of weighing the evidence. It wasn't an IHSS case, it was a waiver case. The child had a condition that required a nurse to do wound care because his skin could open up at any time. And we were at the hearing, and I had the child's plastic surgeon testify about the child's condition and why a nurse was necessary. The state, because this was a Medi-Cal case, the state had a doctor who reviewed some records, never saw the child, never treated the child. And at the hearing, under cross-examination, he couldn't answer some very basic questions about the child's condition. And that showed that he really didn't know the child's condition all that well. And so that kind of made him look like he didn't, like he really didn't know. And that his testimony shouldn't be given that much weight as compared to the plastic surgeon who had been the treating doctor for this child for years. And so I lost at the hearing because the judge found that the weight of the evidence favored the state's doctor. Well, I went to court. I filed a writ in Superior Court, and one of my strong arguments was that the weight of the evidence didn't support the judge's decision. And I spelled out all of the evidence that was presented in the case, including the doctor. That was a big piece of it. And I won the case because my child's doctor's evidence had more weight than this doctor who barely looked at records. So weight of the evidence is really important. The quality of your expert too. If you have a case that involves some kind of specialty and you bring a general practitioner to talk about something that's within the realm of a specialty, and the other side brings that specialist, well, the judge is going to probably give more weight to the specialist because the specialist has a specialty that the general practitioner doesn't. So anyway, just so that you know. Okay, so we've talked about knowing what your issue is. And by the way, I know you probably have a lot of grievances against the IHSS program. This is not the time for mom, for example, to start talking about all the things that she's not happy with the IHSS program. The judge is going to stop her right there and say, we're not here for that. We're here because the county wants to take away the protective supervision. So I am not going to, sorry, I didn't turn this off. I am not going to hear about any more of this. They don't have time for that, and it's not an issue in the case. If you had any grievances, you should have aired them long time ago. So issue, did I just lose? Okay, hold on a minute. Issue, okay. Know what the law is in your case. And now mom has to remember, she's going to have to show that that Emilio continues to be non-self-directing, and that he requires 24/7 supervision. So she's got to get that evidence, right? And so how does where does she go? Maybe the IEP, the triennial. He's a regional center consumer, so maybe the IPP has that. One word of caution: don't just like throw a bunch of documents and hope that something sticks. You really need to go through your documents and make sure that what you are going to provide at the hearing really is going to make a difference. Make sure that the documents that you submit all are factually accurate, right? If the IEP says something about an issue and the IPP says something different, who's the judge to believe? Parent has signed both. When you sign an IEP or an IPP, you need to make sure that everything that is in there is factually accurate. Let me give you an example. So I was talking to a monolingual Spanish-speaking mom. County had denied protective supervision. I asked, what documents did you give the county? She said the IEP and the IPP. And I said, fine, send them to me. She sent them to me. In the IEP, in English, it said, child only needs to be supervised while at school. I call mom up and I say, I know why they denied it, because the child needs to be supervised, needs to have the need to be supervised 24/7. And in the IEP, it says that you said that he only needs to be supervised at school, and you signed it. And she said, no, that's not what I said. I was at the IEP meeting, and they've practically forced me. I felt forced to have to sign it, and they told me they were going to send me a Spanish version down the line. And I trusted that what was in that IEP was what was said. And I never said that. And I said, well, that's how you're going to have to explain it to the judge, because there's no other explanation, right? And so you need to be careful about what you are submitting. Make sure it's going to be helpful to you and that everything is factually accurate. Emilio's mom may reach out to the doctor or specialist to get not only the records that could be useful, but also a letter from the doctor. A letter from the doctor that addresses Emilio's disability, why Emilio's non-self-directing, and why he needs 24/7 supervision. Now, if mom never talked to the doctor or specialist about behaviors, this is a good time to talk about the behaviors. And so the letters are important, but if they're good letters. If the letter says, I'm Emilio's doctor for the last 5 years, he has autism and auditory processing disorder, and he needs to be supervised. That's not a really good letter, because it's not addressing the two criteria that the county is using to take away the protective supervision. The SOC 821 is a form that the county asks mom to have a doctor fill out that indicates the functional limitations in the areas of orientation, memory, and judgment. That document in and of itself will not give someone protective supervision, even if the doctor were to have checked off severe in each category. It's a document that's considered with other evidence in total to determine whether the person qualifies for protective supervision, the criteria. So that could be helpful in the case. Emilio receives ABA services, so maybe getting records from a provider that talks about behaviors that he had during the day, during the time that he had his ABA provider there. Maybe a letter similar to the letter from the doctor from the ABA provider. Witnesses could be family, friends, neighbors, people, let's say that one night the neighbor woke up to noise in the street and went out and saw that there were police officers there and talked to the parents and was told that Emilio had eloped. They didn't know where he was. They didn't know when it happened. And that 3 hours later, the police brought Emilio back home. He didn't really understand where he was or what was happening. Well, that's a good one for non-self-directedness, and that's a good one for needing to be supervised 24/7. Now, what I used to do with hearings is that I would prepare declarations for the witnesses we were going to use. A declaration is the testimony that the witness is going to give, signed by the witness under penalty of perjury. And I would use those at the hearing. To prove my case. I also have had witnesses testify by phone. It's a little tricky by phone because what if the witness doesn't answer, right? Well, in that case, you would ask the judge to continue the hearing to have that witness appear or get a declaration from the witness. Witnesses can also appear in person if you're going to have an in-person hearing. What happened at the home evaluation could be important. Maybe mom told the social worker about new behaviors. And when mom reviewed the file, she didn't see any of that in the form, any of that information. Or there is wrong information in the form that the social worker used to do the reassessment. So, and if you have someone present when the assessment's being taken place, writing down what was asked, answered, length of the evaluation, compared to the time they took to have you sign all those papers, that's all important information, and it could be important in the case. Hazard log. If mom hasn't created a hazard log, this is a good time. Every day, what was the behavior? What happened? What was the intervention? Was there injury or not? It's always, it can show that the behaviors are not, they could happen at any time and what they are. So a hazard log could be very good. If the person is a regional center client, the regional centers have these forms called the CEDAR, and it describes the person's memory, judgment, orientation. So good to have if the information in there is useful. Mom can also submit photos of injuries, if there were any. You don't have to be injured to get protective supervision. Maybe there are videos of a behavior of something that happened. I would only recommend that if someone else is taking the videos, but if the parent and the child are the only ones in the home, of course, you're not going to want to videotape the thing, because you risk the child getting hurt. But if it's possible for someone else to be videotaping what's going on, that could be helpful. Incident reports, police reports, like in the situation of the neighbor, there was a police report that could be very useful as evidence. The other thing that mom's going to need to think about is whether she wants to prepare her own position statement. She doesn't have to, and it would be similar to what the county did. Procedurally, she got this notice on this day saying they're going to take away the protective supervision for these 2 reasons. I disagree. Reason 1, Emilio continues to be non-self-directing. This is the evidence I'm going to be presenting. Number 2, Emilio continues to need 24/7 supervision. This is the evidence that I'm going to be presenting. She should also have at the hearing, she should have a checklist of the things she wants to cover so that she does, so that after the hearing, she doesn't say to herself, oh my gosh, I forgot to do this or say this. Because she could be a witness too. She could testify as to here in the case, even though she's representing her son at the hearing. If she's going to have a hearing that's not in person, I suggest that she get that whatever she's going to submit, evidence and perhaps position statement, to the State Fair Hearings Office at least the day before the hearing. If she's going to have an in-person hearing, she could bring everything to the hearing, and she's going to have to bring 3 copies of everything for her, for the county, and for the judge. The other thing she's going to have to do is prepare questions. If the social worker who did the assessment is going to be there, and she can cross-examine the social worker, why didn't you put in the form and the reassessment form the behaviors I talked to you about? Why do you have this information here when I never said that? Kind of question the social worker's, assessment, quality of assessment. Sometimes you're also questioning the social workers claiming that Emilio is self-directing. Well, what does she know about autism? What does she know about, how is she trained? What kind of training did she receive? What does she know about auditory processing disorder? What kind of training background does she have? What does she know about Emilio's autism? What does she know about his auditory processing disorder, right? When you're cross-examining, you're trying to show the judge that the opinions that the social worker has are really don't have the foundation that needs to be in order to provide, a good opinion. If mom is going to have witnesses at the hearing, she's going to have to prepare the questions for the witnesses and review the questions with the witnesses too, so that they know what is going to be asked. There might be other people that, the county may bring a psychiatrist to the hearing or some kind of other healthcare professional, and you just need to be prepared for that. So at the hearing, it doesn't look like this. This is like in Superior Federal Court. You're going to walk into a room. There's a table. The judge is going to be at the head of the table. Claimant, the person who filed the fair hearing, is going to be on one side, and witnesses on one side, and the county and their witnesses on the other side. That's all. Nothing as formal as this. So who's going to be there? The judge, the appeals specialist, the social worker, perhaps a supervisor, perhaps other people, you, the claimant, your authorized representative, perhaps witnesses, an interpreter. And by the way, I've been at hearings where the interpretation has been horrible, really bad. We had to continue a hearing 3 times before we got a good interpreter. And so the judge would call the interpretation service to get another interpreter. We would start again. And then even the county objected to the interpreters. One interpreter hung up on us because we were complaining. Anyway, the judge had to secure an interpreter in another way, but it's really bad. And I would suggest that if you're going to go to a hearing and you need an interpreter, to bring someone who knows both languages so that they could inform the court or, the judge when this is not happening, when it's not happening correctly. The record is the evidence in the case, and evidence comes in 2 forms: the testimony that you gave at the hearing and the documents that were entered into evidence. And so once all the witnesses have testified, the judge will close the record, meaning no more evidence can be presented. Sometimes when you're in the hearing, either the county or the claimant may think, oh my gosh, I forgot to bring this document. Well, I'm going to ask the judge to leave the record open so that I could submit it. And the judge will mostly comply. I've never seen it not happen. But the judge will say, I'm going to give you a week to do this, and then I'm going to give the county a week to respond to that evidence. So that's leaving the record open. Otherwise, it's closed. No more evidence comes in. The general sequence of events, let me just tell you this. There are some judges that are very laid back. They're going to let each party do what they want, pretty much. And there are judges who are very active. They'll be asking the questions because they know what they want, right? They know what they have a sense of what they need. And sometimes, especially if you're not represented, sometimes you might go off into tangents. And so the judge brings you back and should do that. The judge should be there to try to get all that evidence that is needed in order to decide the case. So you're going to have some very laid back judges, some very active judges, and in between. The judge will swear witnesses, will go through general procedures of the hearing, will ask if the parties will review the evidence that's being submitted by both parties and ask if either party has any objections to any of the evidence that's being presented. If there are objections to the evidence, then there will be a discussion about that there, and the judge will decide at that moment, usually, to whether or not to allow the evidence in other words, to be considered. So the judge will decide what evidence will be considered. And then the judge will go to, in the case of Emilio, the judge is going to go to the county and say, okay, explain your position. And, they have the initial burden. So what changed between last year and this year that now you say that Emilio is self-directing and doesn't need 24/7 supervision? The appeal specialist may question the social worker who did the assessment or any other experts they have or people they have. And then Emilio's mom is going to have the ability to cross-examine the witnesses. And then the judge is going to ask Emilio's mom, well, explain your position, why she disagrees, and then go through the evidence that she has to support. If that includes witnesses, and then she has to question her witnesses, and then the appeal specialist will be able to cross-examine those witnesses. And that's the general sequence. County's responsibilities at hearing, the MPP, here we go again, the regulations on procedure. They have to summarize the written position statement, examine county witnesses, cross-examine claimant and any witnesses, respond to any questions from the claimant or the judge concerning the case, have the case record available at the hearing, have the burden of going forward in the hearing, and authority at the hearing to make binding agreements and stipulations on behalf of the county. So once the witnesses have testified, the judge will give instructions as to next steps. Usually the timeline for a decision is 90 days from the end of the hearing, unless you waived it, especially if you can ask for continuances, they're going to ask you to waive that deadline. If they don't issue a decision within the time that the law requires, they get penalized for every day that the decision is not issued. I have had a case where I got a call from the client saying, I just received a check. It was like, I don't know, $13,000. And it wasn't a retro award. It was because the decision took so long, and the county, the state actually, was penalized monetarily every day for, because they were late rendering the decision. So that happens too. If the judge left the record open and you ask that the record be left open, you need to comply and make sure you get your evidence in on time. So the judge will issue a decision, but the director of the California Department of Social Services can change the judge's decision, and it's called an alternated decision. So for example, let's say that the judge decided that Emilio continues to need protective supervision, and the director changes that decision. The director has to have a legal and factual basis for changing the decision. It can't be just because the director doesn't like it. And some alternative decisions are wrong, but you're going to need to go to court to show that. And some judges' decisions are wrong too, and you'll have to go to court or ask for a rehearing, or ask for a rehearing. But so in Emilio's case, let's say the judge decided that, yes, he should continue with protective supervision. It was alternated. So mom is going to receive the judge's decision, and it's going to say void on it. On top of that decision is the director's decision explaining why the director changed the judge's decision, partially, wholly, whatever the director did. The decision will tell you about your right to, it's not really a right. You can ask for a rehearing. It doesn't mean they have to give it to you, but you can request a rehearing. Your next level of appeal is really a writ of administrative mandamus in your local superior court. If you win, you can ask the court to award attorney fees to your attorney. And usually, the judge in superior court is going to look at the record. A new evidence is rarely admitted. So that's why the evidence in the record is so important in the administrative law judge hearing. Sometimes the judge will issue a decision, or sometimes the superior court judge will remand the case, send it back to the administrative law judge, to the state fair hearings to have maybe another hearing on the whole issue, part of the issue. There are different remedies here. So the hearing is recorded, and you can ask for a copy of the recording. That's your oral evidence. Everything that happened at the hearing was recorded. If you're going to go to superior court and you're looking for attorneys, that attorney is going to want to review the record to see if you have a good case, right? And part of the record is the testimony. And where do you get that? From the recording. So you would call state fair hearings and ask for a recording. I think they have, there's a small fee for getting it. A little bit about rehearings. The MPP 22-065 talks about it. You have to request a rehearing 30 days after receiving the decision. And you have to state why you're asking for a rehearing. And you have to also indicate when you got the decision, because they're sticklers on the 30 days. If you want to introduce new evidence, you have to describe and submit the new evidence, state why it wasn't submitted earlier at the hearing, explain why it's material and how it will change the decision. And so it could be denied or it could be granted. And if you're granted a rehearing, you're going to have a rehearing. And the evidence and everything that was presented at the original hearing will be part of the record. Okay. After the hearing, there's another regulation here that talks about complying with the decision. So immediately upon receiving the decision, the county shall start to initiate compliance. And if it has 30 days to do this. And if the county is not complying or partially complying or didn't comply correctly, you can reach out to the director of CDSS or state fair hearings. I would reach out to state fair hearings and say the county's not complying. And CDSS or actually state fair hearings will make sure that the county takes the necessary steps to comply with the decision. Resources, we've got just a publication about representing yourself at state fair hearing tips. And we have our manual on IHSS has a whole section on appeals. So we have our intake line. If you have specific case you want to discuss, you can call us on our intake line, and you can also visit our website. We have a lot of publications on IHSS under our resources section. So that's where you'll find them. So we're going to go ahead and stop the recording, and we're going to go ahead and take questions.